We'll now recognize the gentleman from North Carolina, Mr. Meadows.
Thank you, Mr. Chairman. Mr. Lennox, let me come to you, and feel free to have Ms. Costello jump in if she can illuminate the answer better. On March of 2015, Secretary Clinton publicly said, and I quote, "I opted for convenience to use my personal email account, which was allowed by the State Department." Close quote. She went further to say, "The laws and regulations in effect when I was Secretary of State allowed me to use my email for work. That is undisputed." Close quote. Are those accurate statements?
Well, I hesitate to comment on public statements, but I will say that our report shows that...
well, we're in a public forum now, and obviously a lot's been said about it. Are those accurate or not?
But I can tell you our report said that she didn't have approval from senior officials of the department, and we don't believe it was permitted, both under the rules and none of the officials, the senior officials who were there at the time, gave her approval or were even aware that she had a server, according to them.
So let me see if I can digest that long answer into a very short, concise statement. It is not an accurate statement.
Again, she didn't have approval. So,
okay, so Ms. Costello, would she have required approval in order to be able to use a personal email according to regulation? Would she have required that kind of approval?
Ms. Costello, we have to. I need you to bring your chair up and sit next to Mr. Lennox, if you would, because we need to be able to capture that for our recording purposes. She was sworn.
I was.
Yes.
Can you hear me?
Yes.
Okay. So in order to exclusively use personal email for official business, Secretary Clinton would have required approval. The reason we know this is because the officials we interviewed at the department, both in the Office of Diplomatic Security and the Office of Information Resource Management, told us that. And in telling us that, they were relying on a department policy that was put in place in 2005, which says that day-to-day operations must be conducted, I'm paraphrasing, but must be conducted on authorized information systems. And so the implication there is any exclusive use would be a day-to-day operation and shouldn't occur without approval.
So that created a red flag for your investigative team?
As we reviewed the policies that were in place by the department, yes, it was something that we considered very carefully in evaluating the evidence that we obtained.
So her statement that this is undisputed would not be accurate. So I won't make you make a reference to the rest of it, but obviously it's disputed if we're disputing it here today.
I would say that in relying on the interviews that we conducted with the officials at the department, who would be the people responsible for implementing these policies, the answer is yes, it's disputed.
So they would dispute it?
They did.
Okay, and they did. All right, so for the record. So let me go on a little bit further, because so you mentioned who had the obligation. I guess, how difficult would it be to comply with the law, the Federal Records Act, if you are using your personal email account? What would you have to do?
Well, I want to draw a distinction here, because what we were just talking about were the cybersecurity provisions at the department, and now we've switched a little bit.
But to federal records, wouldn't she have had to have printed out those emails and kept those to be in full compliance with the regulation?
Yes. During her tenure, folks in the Office of the Secretary, in order to comply with email records preservation and management policies at the department, needed to print and file those emails. Now you can.
So out of the 30,000 emails that we've had testimony earlier today, how many printed copies of emails, of her emails, did you find?
I don't know, but I can say that we did find, as we reviewed other folks' emails and hard copy files, we did find some examples of
So in more than 1,000 printed?
I'm sorry, I can't hazard a guess on that. I really don't know.
All right. So can we get copies of all those printed emails through FOIA or through subpoena?
Well, those emails.
Because that's the whole reason for the Federal Records Act, is so it would be, so you're suggesting that there is a universe of printed out emails that we can find?
To the extent that other folks who Secretary Clinton emailed did go ahead and print and file.
Oh, so you're saying she didn't print any of them out?
Right, but they do.
Oh, okay. Well, that's a big difference. So she made no printed copies in order to comply with the law. That was somebody else perhaps printing it out, and she happens to be communicating with
Correct, and I'm sorry if I wasn't
Okay.
clear before.
No, that's
What
good. I'm out of
saying
time.
Is that they exist in the department. A few here and there do.
All right. I'll yield back. Thank you, Mr. Chairman.
Thank you. And I think the point that certainly Mr. Gowdy was making is if those emails on a private server were mailed to somebody else who's not involved in the government, then there is no printed out copy as required. We'll now go to Mr. Wahlberg of Michigan.
Thank the chairman, and thanks to the panel for being here. Mr. McCullough, what is the significance of special access programs?
It is the highest level of sensitivity in terms of classification information in the federal government.
The highest level, so beyond classified, secret?
It's the most sensitive information the government has, sir.
How does this classification then relate to the other categories classified as information such as confidential, secret, and top secret? In other words, why is it determined to be the most sensitive?
So you have several levels of confidentiality classification in the federal government. You're starting with confidential. That's the parenthesis C, close parenthesis. That's the lowest level of classification. You go up there from to the secret level, and then you go to the top secret level. And then each of those levels may have handling caveats that are trigraphs, such as ORCON, SCI, and what you're asking about is SAP. So the SAP information would be characterized as the most sensitive, among the most sensitive information that we have in the government in terms of classification. Now you classify things based upon the relative likelihood of damage to the national security if the information happens to be released. That's an assessment that each person makes. An OCA, that's an original classifying authority. They make that assessment when they do classify something. I'm talking about original classification.
Okay.
Derivative classification, you're just taking it straight from the OCA's classification and carrying it over. You don't question whether or not the OCA was correct in calling it secret SI. You bring it over.
Okay. On January 19th, 2016, you wrote to the chairman of the Senate Intelligence Committee, or Intelligence and Foreign Relations Committees, saying that the State Department subsequently announced later, as a result of that letter, that it would withhold 7 email chains because they referenced materials on special access programs. In your letter, you said you had not received the declaration from a second intelligence community element as of that time. Did you ever receive one?
Yes, sir. That intel element provided their declaration, I believe 2 declarations, directly to the Congress via their own IG, via their agency IG.
Is it your experience that senior government officials are often unaware of the significance of special access program designations?
No, sir, that's not my experience.
So it's a normal and expected understanding
Absolutely,
that senior
sir.
officials should have.
Absolutely.
Let me ask both of you then, have either of you in your careers ever seen a situation before where special access program information was discussed over unclassified systems?
No, I can't recall. I've had a fairly extensive career in the IG world. I was an FBI agent for 10 years. I was the head of investigations at the NSA for 8, and I've been the ICIG for about 5. I can't recall a situation where I've come across this particular situation, no.
Mr. Linick?
Well, I haven't, but I haven't been in this, I haven't really been working in this space in terms of, I don't have a lot of opportunity to assess whether others are disclosing special access information, but I haven't seen it in my career.
What repercussions, Mr. McCullough?
Well, and certainly, I'll just qualify my answer. That's not to say it hasn't happened. We do get, in the intel community, when you're dealing with intel information every day, especially for the agencies we call the Big Six, the purely intel agencies, we have employees who are dealing with only classified information all the time. And so there are issues we run into. And in terms of the consequence for that, I couldn't prejudge what a consequence would be in terms of a security process or an administrative misconduct process. But it certainly would be something where the security elements for the intelligence agencies would look at re-adjudicating the clearance, and it would be a significant factor in the re-adjudication. But it's a case-by-case basis for these types of things. There are a lot of factors involved.
But there would be repercussions, undoubtedly, as a result of.
There would be consequences, yes.
Okay. Thank you.
Thank the